Alright, so Rule 117 is a motion to quash. So, what is a motion to quash? Ayaw na naman mapindot. Ayan, so, a motion to quash, MTQ. And a motion to quash is a mode by which the accused can assail the complaint or information on the ground of insufficiency, or defect. Defect in the complaint or information that is apparent therefrom. So, it must be in writing. So, this motion must be in writing, signed by the accused or his counsel, specifying the grounds relied upon, and the court will not consider any ground other than those stated in the motion except lack of jurisdiction over the offense. So, ang motion to quash, this is a sui generis motion, no? So, hindi siya pwedeng i-file kung hindi naman founded on the, section 3 on that 1, 2, 3, 4, 5, 6, 7, 8, 9 grounds, no? So, yan lang yung grounds for motion to quash. So, we have to memorize that. So, section 1, sinasabi dyan, time to move to quash. So, at any time before entering his plea, the accused may move to quash the complaint or information. So, tatandaan, at any time before he enters his plea. No? So, before siya mag-enter ng guilty or not guilty. No? So, the form and content. So, the motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its legal grounds. The court shall consider no ground other than those stated in the motion except for lack of jurisdiction. So, except for lack of jurisdiction over the offense. Kasi kung wala siyang jurisdiction, si court, hindi niya rin pwedeng i-try yung case. So, yung grounds, ayan, section 3, 9 yan. So, the accused may move to quash the complaint or information on and off the following grounds. So, ang mnemonics natin dyan is F, J, joke, meld. Wala lang. Basta yan yung pagkakasunod-sunod din kasi. So, yun. The facts charged do not constitute the offense. F. 2. The court trying the case has no jurisdiction over the offense charged. 3rd. The court trying the case has no jurisdiction over the person of the accused. 4th. That the officer who filed the information had no authority to do so. 5th. That it does not conform, conform substantially to the prescribed form. And then, more than one offense is charged, except when a single punishment for various offenses is prescribed by law. M. And then E, when the criminal action or liability has been extinguished. And then letter L, when it contains averments which, if true, would constitute legal excuse or justification. And lastly, letter D, double jeopardy. Wala dyan yun. Pero, yung parang dinefine kasi dito. So, when the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. Previously convicted or acquitted. So, yan ay double jeopardy yan, diba? Yan. So, section 4. Okay. So, before we proceed to section 4, let's go back to the time to quash, no? So, section 1. So, sabi dyan, di ba, the accused may move to quash the complaint or information at any time before he enters his plea. Otherwise, he waives his objection on the grounds listed in the rules, except kasi kapag after plea ka na, winave mo na, no, yung mga grounds na ito for to file a motion to quash, except nga lang. So, kahit after plea, pwede to if the facts charged do not constitute an offense, if there is if the court has no jurisdiction over the offense or the person of the accused, if the offense has already been extinguished, if the officer is not authorized to do so, and when there is double jeopardy. Baligtad pala to, no? Ayan, so problem. The accused before entering his plea filed a motion to quash, alleging that the time of the commission of the offense he was out of the out i- uh, is not in the Philippines. So the court denied the motion to quash. Is the court correct? Yes, because his absence in the Philippines is not among the grounds of the motion to quash. So, ito lang talaga yung kailangan nating i-memorize sa motion to quash. So, when the court granted the motion to quash on the ground of absence of probable cause, is the court correct? No, because not finding a probable cause is not among the grounds to file a motion to quash. So, mamaya remedies, nandito siguro yan. Wala. Sige. So, paano kung nag-grant naman ng court ang motion to quash, no? So, if granted, ano ang remedies ni prosec, remedies of the prosecution? So, tatlo lang yan. So, either he amends his complaint, he refiles, or he appeals, which we will talk about later. Yan. So, let's read muna ang section 4. Ito na pala yan. Amendment of the complaint or information. So, yun. So, when the information, when the motion to quash is based on the alleged defect of the complaint or information which can be cured by amendment, the court shall order the amendment to be made. So, if it is based on the ground that the facts charged do not constitute an offense, so kailan pwedeng ipa-amend kay prosec kapag the facts charged do not constitute an offense? The prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution files to make an amendment or the complaint or information still suffers from the same defect. So, ano pa? Kung saan pwedeng mag-amend si prosec, the facts charged do not constitute an offense. It does not conform substantially with the form prescribed by law. If more than one offense is charged, and if it contains averments that which, if true, would constitute legal excuse or justification. So, ang gagawin ng court, he will not grant the motion to quash outright, but he will allow the prosecution sufficient time to amend. Pero, kunyari, kahit na binigyan na siya ng time to amend and the prosecution fails to amend, or if the defect still subsists despite the amendment, the court will now grant the motion to quash and dismiss the case. So, kung magre-refile naman, ayan, so ito tayo sa section 5. Ito kasing section 4, yan yung amendment. Ano ba yan? Amendment yan. Tapos kung refiling, itong section 5, effect of sustaining the motion to quash. So, if the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in section 6 of this rule. Yan. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if having been made, no new information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged unless he is also in custody of another charge. So, yung section 6, an order sustaining the motion to quash is not a bar for another prosecution. An order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in G and I. So, ano daw yung G and I? If there is double jeopardy and the crime is extinguished. Ayan. So, ito namang section 6 ay kapag aapela si prosec. Appeal. Ayan. So, kapag magre-refile kasi si prosec, ang ground dyan ay kapag no jurisdiction over the offense or the person of the accused. So the court shall grant the motion to quash and dismiss the case, and the prosecution may refile the information. Kapag aapila naman si prosec, ang grounds dyan ay yun nga, extinguished and double jeopardy. Yan, sabi niya yung G and I. Yan. So, the case will be dismissed and then the prosecution will appeal from that order of dismissal. So, Section 7, former conviction or acquittal, double jeopardy. So, when the accused has been convicted or acquitted or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pleaded to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charged, or for any attempt to commit the same frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charged in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which necessarily includes the offense charged in the former complaint or information under any of the following instances: when graver offense developed due to supervening facts arising from the same act or omission. The facts constituting the graver charge became known or were discovered only after the plea was entered in the former complaint or information. The plea of guilty to a lesser offense was made without the consent of the prosecutor and the offended party, except those provided in Section 1F of Rule 116 if nabigyan ng notice si offended party, but despite notice, he failed to appear. In any of the foregoing cases where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for a graver offense. Okay, so before we proceed with provisional dismissal, let's talk about the ground that the officer has no authority to do so. So, let's go back. Ayan ay makikita sa Rule 112, Section 4, Paragraph 3. Ano bang sinasabi dito? Sabi kasi dyan, no complaint or information may be filed by an investigating prosecutor without prior approval of the city or provincial prosecutor. So, ang tatandaan lang natin dyan, if kunyari, dalawa kasi yan isang information, tapos yung isa ay yung resolution. And so, kung may approval, kung walang approval ang information, pero may approval sa resolution, it is not a fatal defect, no? So, nako-comply pa rin natin yung officer has an authority. No? So, yung Rule 112 is complied. So, no fatal defect. But if the information has no approval and the resolution has no approval, then the complaint and information will be dismissed on the ground that the officer has no authority to do so or to file the information. So, this ground can be set up anytime. So, before or after the arraignment, pwede yan. So, paano naman kung yung the one who signs is not a prosecutor? Kunyari si offended party yung pumirma sa information. Ayan, so the information is void because the court will not acquire jurisdiction over the offense, and the ground for motion to quash is that the court has no jurisdiction. So, dun tayo sa J pag ito, officer. Ayan, so now, okay, so now let's proceed to Section 8, the provisional dismissal. So, a case shall not be provisionally dismissed except when except with the express consent of the accused and with notice to the offended party. The provisional dismissal of offenses punishable by imprisonment not exceeding 6 years, or a fine of any amount or both, shall become permanent 1 year after the issuance of the order without the case having been revived. With respect to offenses punishable with imprisonment more than 6 years, their provisional dismissal shall become permanent 2 years after the issuance of the order without the case having been revived. So, ano ba ang requisites ng provisional dismissal? So, 1, the dismissal must be with express consent of the accused. Yan. 2, it must be with notice to the offended party. 3, that the court issues an order dismissing the case provisionally. So, provisionally dismissed siya by the court. And 4th, a copy of the order shall be served to the prosecution. So, provisional means it is not permanent. So, the criminal case may be revived but there is a time bar. So, yun yung sinasabi ng Section 8. So, kung yung time bar niya is kung less than 6 years or fine or both, ganun ang penalty. The provisional dismissal shall become permanent 1 year from the issuance. 1 year from the issuance of the order. Pero kung more than 6 years ang imprisonment, the provisional dismissal shall become permanent 2 years after the issuance of the order. So, the issuance of the order is from the date the copy of the order is served with the prosecution. So, dito yan binibilang from the time it was served to the prosecutor. Yan. So, who may move for provisional dismissal? It may be the prosecution or the accused or jointly. If the one moving is the accused, then there is an express consent to the dismissal. So, failure to move to quash or to allege any ground thereof, the accused to assert any ground, the failure of the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in the said motion, shall be deemed a waiver of any objections based on the ground provided for in paragraphs A, B, G, I of Section 3 of this rule. So, yon yung facts. The facts do not constitute an offense. B, yung jurisdiction over the offense. If the crime has already been, the criminal action or liability has been extinguished, and if there is double jeopardy. And so that ends Rule 117.